Good afternoon. Thank you for coming. Associate Cincotti, Associate Yammine, and Associate Fernandez. I really would like to know why we were convoked and what is this meeting about.
Thank you for coming. My intention of calling this meeting with you is to discuss the case of one of our firm's most important clients, the Greenview company.
Yes, I remember what happened.
Joana Torres, one of the directors of the company, just found out about an adjoining land of the company's golf course that is available for sale. She's interested in buying it, but wants to know if she must notify the company first, since it may greatly increase the value of the golf course if attached the art of terrain.
According to the Westland Principle of Corporate Law, Section 5.05, Part A3, a director has a duty of loyalty and a duty of care to his company, and he must act in the best interest of this company. In this case, the most important principle that we can apply is that of loyalty, which states that he cannot take advantage of corporate opportunities. In this sense, being in front of a corporate business, she must make sure she doesn't comply with any of the following requisites. The first requisite is that the company has the capacity to engage in it. Second, that the offered party is willing to offer to the company. Third, that the company shows interest in the terrain. But last and not least, fourth, that the company expanding the space of the course is related to the current or future interest and business of the company.
Well, according to Mr. Yammine's statements, of course, Mrs. Joanna complies with all the requisites, so she of course may not buy the golf course territory.
Yes, that is true. She should give the company the benefit of uncorrupted business. In any case, before recommending her not to buy it, I believe that we should apply a test established by the doctrine on corporate opportunity.
Can you further explain uncorrupted business?
Of course. The specific test that I'm proposing is a two-part test. The first part requires a determination of whether the opportunity falls within the line of business of the corporation. Basically, it's about evaluating all of the four requisites you just mentioned and making sure that the person, as part of the company, specifically as a director, doesn't comply with these requisites, because if she does, she would be harming possible interests of the company. The second part of this test allows for a justification to relieve liability from an affirmative answer to the first part. That is, if even when these requisites are present, the stakeholders decide that they do not want the property, there is a chance for a justification to relieve liability.
Well, then it's clear what we must do. I believe that first, we should let the client know about the results of the two-part test. Second, we will ask for further information regarding the requisites mentioned by the Associate Yammine, established in Section 5.05 Part 3 in the Principles of Corporate Law. And finally, I believe that we should call for a shareholders meeting to offer the golf course property to them, and if they regret it or they reject it, we can advise our client to buy it for herself. Do we all agree?
Yes.
Yes.
Great. Then I will ask for the secretary to give us all the minute of this meeting, and this meeting is adjourned.
Thank you.